Good afternoon, sir. Can you see and hear me?
Yes, thank you.
Thank you. Good afternoon, Mr. Singh. Can we turn to an issue that you raised before lunch, namely what was on the schedule of non-sensitive unused material on the 8th of September 2010. You called it the September 2010 schedule, and who signed it, and just close that issue off, if we may, by looking at poll 305-5217. Can you see this is a schedule of non-sensitive unused material in the case of Seema Misra?
Yes.
And would this be completed, i.e. the typing on it, in column 1, 2 and 3 by the disclosure officer?
Yes.
And would the comment column in column 4 be completed by the reviewing lawyer?
Should be, yes.
In legal services?
Yes.
If we look at this schedule, if we just scroll down to the foot, we can see it's dated the 8th of September 2010.
Yes.
I.e. the one that you were referring to, and you asked whether the email exchanges that I was asking you about were on the schedule of unused material, and I said no, they're not. So if we just look at the schedule to start with, we scroll up, please. If you just scroll through all of those items, you can probably do this quite quickly, and then scroll down, and then over the page, and scroll down. You can see that no emails are referred to.
No.
So not just the ones I was speaking about at the time, but no emails concerning liaison with Fujitsu or Gareth Jenkins over the commissioning or contents or parameters of his witness evidence are included, are they?
No.
If we go back to page 1, please. And whilst we're here, we'll come back to it later, but this schedule of unused material does not contain any drafts of any of his witness statements, does it?
No, it doesn't, no.
Did you know in 2010 that there was an obligation under the law that it had existed under the Code of Practice promulgated under the CPIA 1996 to disclose as unused material drafts of witness statements where they were materially different from the served version?
I can't remember now, to be honest, but I would have assumed I'd been on the courses. I would have been aware, but I can't. I can't recall it.
Assuming that you were aware of that, we're going to see later this afternoon that there were a series of draft statements that passed through your hands, which were very materially different from initial drafts. And in particular, they contained drafting suggestions made by Warwick Tatford.
Yeah, Mr. Tedford, yes.
And none of those were disclosed. How did that come about?
Who signed this? Have I?
Well, you can see at the foot of it, it's signed by Mr. Longman.
No, with the reviewing lawyer. Is it me? Because I know there was a number of people dealing with it.
Well, let's start with how it was supposed to work.
Yeah, please.
The disclosure officer was responsible for collecting together the material and deciding in the first instance whether it required to be listed on this schedule or a sensitive schedule or not at all. Agreed?
Yes, agreed.
They would submit the schedule to the reviewing lawyer.
Yes.
What function did the reviewing lawyer perform in relation to the schedule of non-sensitive material?
Well, he need to, certainly review every single information he has, or he should have, or if he hasn't, to get the investigation officer to get it over to him, or put it in the schedule for him, and then having reviewed it, finally conclude that it's on here.
And would the reviewing lawyer sign it?
If he's happy with it, he will only sign it if he's happy it's all complete. Yes.
You'll see the way this form is designed, that there isn't an obvious place for the reviewing lawyer to sign. The signature that's underneath that GRO there is Mr. Longman's signature.
Oh, is it? I don't know. I mean, I presume that there's a reviewing lawyer. Maybe we need to. I don't know whether I dealt with it, whether I signed it next to where this reviewing lawyer is.
That's what was supposed to happen, was
Yes.
it? That it was signed next to the words reviewing lawyer to show that the two-person process
Yes.
of the disclosure officer on the one hand and the independent of the disclosure officer, the reviewing lawyer on the other, had each applied their minds to the contents of the schedule.
Yes.
And so would you get copies of these documents, here 1 to 11, when
Yes.
you got this schedule?
Oh, absolutely. Yes.
Right.
You should be enclosed with it.
So that's what the disclosure officer is submitting to you, a schedule plus a copy of the documents that are mentioned in the schedule.
Yes.
Yes? What about material that's not mentioned in the schedule? How did the reviewing lawyer go about ascertaining what steps had been made to collate material to decide whether it should go on the schedule?
Well, you're meant to review the whole case and presumably make a list of what should be there. The matters just mentioned about the drafting of the statement or the amending of it, and as you go through it, presumably you make a list. And I think yesterday you enclosed in one of the documents as to what should be on it, plus depending on the kind of case it is. And presumably here we're requesting a lot of information from Fujitsu, and it's not forthcoming. And if those matters that underline the prosecution case and assist the defence, that's the test. And the fairness of the trial, all that needs to be requested, asked for, searched for, and then subsequently listed before you sign it off or submit it to the defence.
In this case, this wasn't one of those cases where the investigatory work had been carried out by and only by the investigator, and the reviewing lawyer was not cited on any of it. We've seen from the email exchanges that we've looked at so far that you were included in a series of emails which made it clear that you were in possession of relevant material.
Yeah. It's on the file. It should be on the file.
And so why was that material not listed on the schedule?
I honestly can't say why, but I don't know. When was the actual information sent, the non-sensitive material, the schedule, when was it sent to the defence?
Sorry, when was the non-sensitive material?
It must have been served on the defence, this being the final.
I don't know. At some point, presumably after the 8th of September 2010.
Yeah, I know certainly this matter was dealt with the other lawyers in the office, and I think around about that September 10, I was away for a long period. I wasn't even in the country. That's the reason why. I can't really...
So what did you do to tell the new lawyer, look, I've been party to dozens of emails in which the third party, Fujitsu, has been asked a series of questions, some of which they've answered, some of which they've declined to answer or feel unable to answer. That material needs to go on an unused schedule. Here it is.
The person who would have dealt with it would have been my supervising officer.
Who was that?
Supervising officer
Who was that?
Or the, the head of criminal law team.
Who was that?
Rob, I think Robert.
So he took over the file whilst you were away, did he?
I think he always kept an eye on it. Because,
No, you're talking about something different here, Mr. Singh.
yes,
You're telling us that.
He
You're telling us
took
that.
over. He took over for that period I was away.
Okay, when did he take over from?
I think probably, I don't know, I think it's probably about end of August, beginning of October.
So he took over from the end of August until the beginning of October.
Yeah, I think I was away for a long period, about 3 or 4 months. I wasn't even in the country. I had some things to sort out, and I got the leave to go.
And so presumably you said, look, Rob, we've got all of this unused material here. I've got it. It's on my file. It's on my email inbox and outbox. Here it is. This needs to be listed on the unused.
This is one of those cases, I think we sat together and reviewed it constantly over a period of time. I think it was sort of more or less up to date because it was one of those cases where I feel a lot comfortable with the fact that it's been looked at, reviewed by the barrister who would deal with the trial, if it came to the trial, and subsequently my line manager. So if there was anything I overlooked, he would pick it up, and vice versa. And that's one of the reasons why the disclosure was dealt with the way it did, in the fact that I kept the counsel, the barrister in the case, up to date with everything and all seeking advice as the matter progressed. Because it's one of the...
I'm asking you, Mr. Singh, about what steps you took
Well,
to ensure in this period of absence that you're telling us about, hold on, that
all right, okay.
the material that you were in possession of that undermined the prosecution case was included on a disclosure schedule. What steps did you take?
I think, firstly, the fact that I think he was my line manager, and top of it, that we were dealing with it, together. And then I think before I left, I think we had the case we had the date for the trial, and I don't know whether we sat together and he made notes, or I actually dictated notes. I don't know how now that exactly how this came about.
Do you accept, Mr. Singh, that it's a serious dereliction of the prosecution's duties?
Yes, of course.
Not to have included on this schedule or any schedule of unused material the email exchanges that we were looking at earlier?
Yes, agreed.
And a serious dereliction of the prosecution's duty not to include on this schedule or any schedule the draft witness statements of Mr. Gareth Jenkins, which were materially different from the signed versions.
Yeah.
And your answer to that is essentially you need to ask Mr. Wilson about them.
Yes. Well,
it's not down to you.
No, I accept that fact. Maybe I should have done more, but certainly for that particular period.
What do you think you might have done more?
More in the sense that maybe I should have had something. More in the sense that I don't know, make everybody aware of it. Maybe I should have listed it. I don't know, but I think I sat with him almost constantly, and also I think he more or less on and off took over the case to have a look. I think he was one of reviewing it all the time. I don't know whether he made notes on it, but I mean it's such a long time ago. I can't recall exactly what.
Thank
happened.
you. That can come down. Can I just return to another issue that we addressed before lunch, the extent to which you treated Mr. Jenkins as an expert. And remember, I showed you some emails after the event from, I think, 2012, 2013, which referred to you having instructed him as an expert. Can I just look at some material that bears on that issue from a different angle? Can we start, please, by looking at poll 304 5565? If we look at the second page, please. It's a note from Warwick Tatford. If we go back to the first page, it's an attendance note for a mention on the 7th of May 2010.
Yes,
Can you see that?
yes.
And if we look at the third paragraph, please, if that can be blown up, please. The judge was prepared to break the fixture because it had been fixed without the knowledge of Keith Hadrill's dates to avoid. He was defence counsel. The judge ordered that the experts should compile a schedule of their points of agreement and disagreement. No further directions were made, etc. You would have known by the time of receipt of this document that the court was regarding Mr. Jenkins as an expert. Agreed?
Well, that's what it says, yes.
You would have known personally that by the time of receipt of this document, 7th of May 2010, the court was treating Mr. Jenkins as an expert. Agreed?
That's note by our counsel. I mean, he presumably he was at the hearing, and he.
Yes, but he was giving you a note of what was happened at the hearing.
Yes.
And the judge is referring to the experts, plural, compiling a point of their points, plural, of agreement and disagreement. So you would know that by this time, the court was treating Mr. Jenkins as an expert. Agreed?
Agreed. Yeah.
And so when in your witness statement, do you remember those two paragraphs that I showed you first thing, you said, I didn't regard Mr. Jenkins as an expert, but the court did. You would have been referring there to at least this point onwards, wouldn't you? May 2010 onwards. You knew the court was treating Mr. Jenkins as an expert.
What can I say? Certainly that's what the court.
Yes, and so what did you do from May 2010 onwards to ensure all of the things that I mentioned this morning that a prosecutor must do in relation to an expert were done?
As I say, I obviously.
None of them?
In error.
Is the answer none of them?
None of them, yeah.
Why did you do none of those things?
I can't tell you. Obviously, it's my fault. I take a responsibility that I should have done, which I didn't for some reason or other. I don't know. I can't explain it to you now. But certainly we would have been aware of it because of the note, and certainly some stage, maybe even the conference or beforehand, we should have done something about it in order to comply with it, and we didn't.
Can we move on to poll 305 4763? You'll see this is your own attendance note.
18th of May.
Yes, so 11 days later. And you say the defence had the case listed for mention at Guildford Crown Court on the 7th of May, as they were unable to serve the full defence experts report by the 28th as directed by the court. At the mention hearing at Guildford on the 7th of May, the matter was heard by the resident judge, I think that's meant to be Critchlow, who ordered the defence to serve a full and proper defence experts report on the prosecution, and then the two experts to meet to agree a point of agreement, listed the trial for the 11th of October. So this is in your own hand, a note for the file, where you are recording Mr. Jenkins as being one of two experts, aren't you?
Yeah, well, clearly.
Again, at this time, what did you do to ensure that all of the duties and obligations that you owed as a prosecutor were complied with by this time, at this time?
I in error or oversight, I didn't. I should have done.
Can we move on to poll 305 5118? attendance note in your hand again, 28th of July 2010, telephone call received from Warwick Tatford of counsel in this case. After discussion, he confirmed that they are seeking exactly what they were seeking before, and to respond to the defence that if they wish to disclose these items, they need to make a Section 8 application to court, and that also our expert, Mr. Jenkins, has informed their expert that the material from Chesterfield, that is the logs, is not relevant information that would assist them. So here you've got your counsel referring to Mr. Jenkins as our, i.e. the Post Office's expert. Yes?
Well, yeah, that's what it says. Yes.
What did you do at this time, July 2010, to ensure that the duties and obligations that we went through earlier were complied with?
I'm sorry, it's obviously been an oversight. I mean, certainly I was, it's there in black and white. It should have done, and it wasn't done.
Can we move forward to poll through 4-0-1882, please? And if we just scroll down, thank you. This is a joint statement of areas of agreement and disagreement prepared by Gareth Jenkins and Professor McClacken. Can you see that? And if we go over the page, please. And sorry, go to the last page. And just scroll down. Thank you. You can see it's dated the 11th of October 2010. So just shortly before trial. And if we go back to page 2. This document comprises a schedule of agreement, etc., etc.
Yes.
So this is, would you agree, the kind of schedule of agreement and disagreement that one commonly sees in cases involving expert witnesses?
Well, as I said, this is the first experience of any of this nature. Yes, agree.
When you saw this, did you think, well, hold on a moment, Mr. Jenkins isn't an expert. He's a lay witness of fact. What's he doing signing off an expert schedule of agreement and disagreement?
I don't know. I can't recall exactly what I was thinking at that time. Certainly, all that was referred to the council and also my line manager. I don't know. Nobody is down to me. I agree. I should have picked it up and done something about it.
Do you agree that that's a serious dereliction of your duties as a prosecutor?
Yep. Yes, it is.
Thank you very much. That can come down. Picking up where we left off before lunch, we were looking at the email that Mr. Jones, the head of legal at Fujitsu, had sent you on the 5th of February 2010. Perhaps if we just remind ourselves of that. FUJ 0015 2930. And you remember we were looking at this before lunch, and it's this critical issue of what started as paragraph 7 of Mr. Tatford's advice about getting out of Fujitsu known or recognised errors or issues with the Horizon system, the watering down, as I called it, of that request, the putting of that to Fujitsu and Mr. Jenkins, and the reply coming back, he's not currently in a position to make a clear statement.
Yes.
Can we just look at the draft witness statement that was attached to the emails by looking at FUJ 0012 2723? And if we look at page 2, please. Can you see that Mr. Jenkins internally says, i.e. to Mr. Jones and Ms. Thomas. Brief responses as follows, but I'm not sure that I should put them in a witness statement. And then number 3, this is where I'm reluctant to make a clear statement. I'm aware of one problem where transactions have been lost in particular circumstances due to locking issues, etc., which was cut into the email that you yourself received. And then if we scroll up, please, and a little further, you can see that that is indeed forwarded on to you. Can you see that?
Yes.
What did you think when you read that Mr. Jenkins said he was reluctant to make a clear statement over whether there were known issues or problems with the Horizon system?
Sorry, say that again, sorry.
What did you think when you received a communication which said that Mr. Jenkins was reluctant to make a clear statement over whether there were any known problems with Horizon?
I don't know. I can't think now as to what I was thinking at that time, or what we did about to deal with it.
What about what is said there? It's possible for there to be problems where transactions have been lost in particular circumstances due to locking issues. What further information did you seek from Mr. Jones or Fujitsu more generally as to what this problem was and what the background to it was?
I honestly don't know. I mean, I don't know what it was because I haven't got the whole file. And certainly, you know, I was working with other people. I would have sought advice as to what directions we take from there. Certainly, you know, the barrister is working alongside me together with the head of criminal law team. I mean, I as I say, this is the first case of this nature. That's why I wouldn't have taken that case on by myself. I would have had other people working alongside with me. And it was that period, I think, in that year where I think I took time off, certainly, and we had my head of criminal law team working alongside me, who was caretaking while I was away.
Did you take any steps to understand what the issue was with Horizon which could cause transactions to be lost?
I don't recall. From what you this is the only thing, or whatever you've given in your, you know, the papers you've submitted to me. Apart from that, I can't really add any more.
Given that your counsel, Warwick Tatford, had originally advised the Post Office in relation to its disclosure obligations to ask Fujitsu whether it was aware of any other Horizon errors that had been found at any sub-post office, and this information was conveyed in response, did you take any steps to ensure that the Post Office met its disclosure obligations in relation to at least this information?
I don't recall. I mean, I can't. I don't know. I haven't got the full information in front of me as to what steps we took.
We've seen on the disclosure schedule that there is no mention of any document exchanged with Fujitsu, nor any email exchanged with Fujitsu. There's no disclosure on the unused schedule of any communications with that third-party provider, is there?
Not on that schedule. Should have been.
So this is the 5th of February. Can we look, please, at poll 305 4162? Your email of the 22nd of February to Warwick Tatford and John Longman. And you say, herewith my replies to the defence's third schedule. Be grateful to John if you could read through all the replies, but in particular, detailed responses to a list of them. Responses by the end of business today, so you could forward on to the defence's solicitors. And then at 2, you proposed to say to Izzy Hogg, we're well aware of our statutory duty of disclosure. As you know, the prosecution have reviewed a large volume of material. The only material disclosable is Calendar Place, I think you meant Calendar Square. As we know, Mr. Jenkins is making full investigations so the position can be ascertained. The information that you received from Mr. Jenkins via Mr. Jones and Fujitsu was not disclosed by you in this proposed communication to the defence solicitors, was it?
I don't recall.
Well, it's not there, is it?
Can I just stop for 5 minutes and have a chat with my solicitor on this, if it's possible, sir?
Well, that's a rather unorthodox request in the sense that witnesses don't normally have a chat with their solicitor.
Well, advice then, because
If it relates to the warning I gave you at the beginning of your evidence about self-incrimination, then I will permit it. Does it relate to that?
well, so to a degree, because this information is very old, and you 12, 13 years on, I have not seen that file. I've been away from this type of case. Even my honest belief as to the previous question asked of me by your inquiry counsel as to whether Mr. Jenkins was expert or not expert. Again, there's a lot of information isn't solely down to me because it's sort of done by the whole team because of the nature of the case, and because of this being the first of post office cases where the matter's gone to trial.
All right, hang on, Mr. Singh. In the circumstances that are developing, Mr. Beer, can you think of any cogent reason why I should refuse Mr. Singh's request?
So I think there needs to be a limitation placed upon it, because I
think the limitation in reality will be that I will limit it to 5 minutes, Mr. Beer.
Yes, because I wasn't thinking more in terms of time. I was thinking in terms of content.
No, well, I know. I was simply observing that if I limit it in time, the content is likely to be limited as well. But maybe that's too pragmatic. Mm-hmm. Anyway, all right. Is anyone else representing a co-participant? Does he or she wish to provide a cogent reason why I shouldn't accede to this request?
No, I'm getting shakes of heads from Post Office, Howe & Co., Hodgels, Fujitsu and Gareth Jenkins representatives.
Right.
It's just HJA, I think, you're thinking about.
Mr. Singh, I'm going to afford you 5 minutes, literally. I'm going to specify, since it arose in relation to this document, that the discussion must relate only to the document which is now on the screen, and in particular the highlighted part at paragraph 2, and anything which bears upon that in relation to self-incrimination. All right? So with those words, what's the time now, Mr. Beer?
Just gone 25 past. Should we say 25 to, sir?
Yeah, 25 to 3, we will return. Oh. All right? So you need to get your skates on, Mr. Singh, all right?
No problem.
Thank you.
Sir, can you see and hear us?
Yes, I can, thank you.
Mr. Singh, is there anything that you wanted to convey to the chairman, having had that?
No, thank you, sir. Thank you for the time. It's just to clarify my head. I think I needed time. That's fine. That's okay. Can you ask the question again? Then I can.
Thank you. This draft communication to the defence solicitor, Izzy Hogg, was to tell her that you, the prosecution, were, quote, well aware of our statutory duty of disclosure. As you know, the prosecution has reviewed a large volume of material. The only material disclosable is Calendar Place. And my question was, why did you not reveal the information that Mr. Jenkins had provided you through Fujitsu about a known problem which caused transactions to disappear or to be lost?
This is to Mr. Warwick Tedford and Longman, isn't it?
Yes, it's a draft email.
Draft email. I'm working alongside the council, but I don't recall or remember this. I can't answer. I don't know the. I don't recall.
But do you agree that the information that you had received should have been revealed to the defence? I think you've agreed that already, in fact, before the break. But do you agree that it should have been revealed in this response to the defence?
Again, it's such a long time ago. I'm trying to. Lot of it is basically since I've left doing this sort of work. It's unmanageable, the amount of material I had. Certainly, I do not remember. I do not recall. I can't really assist the inquiry any more than that, because it's not something that I would have retained to give you an answer for. So I don't remember. I don't recall.
Can we look, please, at poll 305 4185? Can we see the email that in fact went out from you to Izzy Hogg? And can you see paragraph 2 of it is in exactly the same terms?
Yes.
You'd been told by this stage that there was a known problem with Horizon, causing transactions to be lost. Why not tell the defence?
I don't know. I don't recall as to where we are at that particular moment in time. I think it's 24th of February, 10. So I don't recall. I can't assist any more than that.
Let's move on. FUJ 0012 2808. Mr. Jenkins, on the 8th of February, is emailing you directly, copying in Penny Thomas and David Jones. And he says, attached is a new witness statement saying what I don't know about Falkirk, that's Calendar Square, and also comments on the third report. And can we look, please, at the draft statement? Poll 401569. Can you see Mr. Jenkins' draft statement here attached to that email to you?
Yes.
And he says, if we just scroll down a little bit, I've been asked if issues found at Calendar Square Post Office in Falkirk could have caused the discrepancies in Seema Misra's case. At this stage, I'm not aware of the details of the problems in Calendar Square Post Office in Falkirk. However, I expect to be able to find out the details of that case and also to compare the failing scenarios with the detailed logs that are to be extracted for the Seema Misra case, and should then be able to make it clear if the scenario is relevant. And so the witness from Fujitsu is saying, I don't actually know about the one problem with Fujitsu that has, with Horizon, that has been disclosed to the defence, isn't he? But I'm going to try and find out.
I don't. I think I can't really recall. I cannot really say. It's just too minute details in this moment in time. I don't know what I was thinking at that particular moment. I don't recall most of what you asked me this afternoon, purely because I've been given a lot of information, and I'm not at a time and place and age to be able to digest all that and say to you one way or the other. I mean, so I don't know, I don't recall it, and I don't remember. So that's all I can assist you with. I don't remember any of that as to how we dealt with it, or why we dealt with it. It's just I don't recall. And I think at the end of the day, what I've done is I've had second set of eyes looking at it all the time, or even third set of eyes. You've got the head of criminal law team and you've got the barrister looking at it, purely because it's something we have never experienced before. And it's the first time I think the post office has gone through this sort of process and system. So that is one of the reasons why I'm copying everything to the counsel, who's well experienced and knowledgeable, together with the head of criminal law team, who'd I think been practiced since 1980. So I am.
You sent this to the head of criminal law, did you?
He was part and parcel of working alongside me. I mean, it's not something that I've done alone.
Have you decided since the break to come back and say, I don't recall, I don't remember?
No, absolutely not. I mean, it's something, 10, 12 years ago. I've not been in practice. I've been doing other things. You work hard early on to be able to enjoy life at a certain stage, and I have been. And it's not wanting to assist the inquiry. I think that's never been my intention, and I have been very clear. I think maybe on the first day I was a little bit nervous because I was nervous in the sense that I've been out of practice, but I think slowly I've been able to slow down, understand what you are asking, and in those circumstances I'm trying to assist. I do not recall this, and I would not recall it to this much detail at this stage in my life and in my career, because I'm not a prosecutor anymore, and I have not been for the last 12 years or so. And I can rest assured this has been done with a barrister on one side and the head of criminal law on the other, plus a principal lawyer. And I think
who was the principal lawyer? Who was also
Juliet McFarland.
She was being copied in on all these emails too, was she?
She had the files on and off.
What do you mean she had the files?
Well, the files was basically shared in that respect.
How were they shared?
Well, the shared. I think there's an email subsequently you will see that she dealt with various aspects of it, because the fact that she was senior, she would take up various matters alongside it. Which I was aggrieved.
We'll maybe get to that email that you do remember a little later.
Yeah, sorry. But you can rest assured it was not the sole... It's a team effort, in effect, because I wasn't comfortable dealing with it alone, because it's, like requesting information, trying to understand it. That's one of the reasons why the barrister, I think you will... he's always been copied in, purely because you had a second set of eyes.
I haven't challenged you on that at all.
Yeah.
I haven't challenged you that
but
many of these things were run past Warwick Tatford. So what you've just told us, that this was a team effort, by that do you mean decisions not to disclose what Gareth Jenkins had informed you? There was a collective decision not to disclose it?
No, not at all. What I mean is that it's not a collective decision not to disclose it. For some reason or rather, I do not recall what we did or what we didn't do. But that is the position. I can't, 12 years on, assist you purely because I don't recall, I don't remember.
Can we move on, please, to poll 305 4056? The same day, now at 9 minutes past 3, you send Mr. Jenkins' witness statement of the 2nd of February and his witness statement of the 8th of February to Warwick Tatford and the investigator, John Longman. Can you see?
Yes.
And you say that you've served them on the defence?
Yes.
Yes? So at this point in time, 3 o'clock-ish on the 8th of February, would you agree that the only instructions that the post office had given to Mr. Jenkins were those that were set out in the email from John Longman that we saw earlier? Please comment on the witness statement or the expert report of Professor McLachlan, versions 2 and 3, and asking him to address his written points 1 to 4. That's the only form of instruction that Mr. Jenkins got. Agreed?
I don't recall. I mean, I don't know. I mean, unless I revisit the whole paperwork from the beginning to the end, and we put the clock back to, year 2010, I can't really assist you one way or the other what we did and didn't do. It was
on the documents we've seen, the only form of instructions that Mr. Jenkins got were requests to comment on Professor McLachlan's reports 2 and 3, and to address the 4 issues mentioned in the John Longman email.
Well, that's what we're trying to collate, is to get the two gentlemen together to work out where we go from there. I mean, certainly there's no intention of any of it. That's the practical approach to it. And as far as to where we are at that particular moment in time now, I don't recall, and I don't remember anything. So I don't recall on that. I can't assist you any further.
Would you at least agree that neither of the witness statements that Mr. Jenkins had provided at this time in draft incorporated the necessary elements of an expert report?
Which statement? Well, as I said to you, it's obviously been overlooked. You showed me the court's decision and my own attendance note, but at that time maybe it's overlooked. It's pressure of work or whatever it is. I'm sorry it wasn't done. But
as a matter of fact, it wasn't done though. So by this time,
yeah.
You're serving 2 witness statements in ordinary form on the defence, and by that time, neither of those witness statements incorporated the necessary elements of an expert report, the things that we discussed this morning.
He was, it was the 8th of February 10. He was considered he just brought in to get everybody to understand the system itself, because he's a specialist. It's a special system, and he's a specialist able to assist the prosecution, the defence, and the court. So I can't say more than that. I mean, presumably, now that you pointed it out, there would have been. I mean, in time, I didn't know. Well, maybe it was overlooked by everybody concerned. There's a number of people involved in it. That we should have done what was required of us. So it's not anything more than that. But he was brought in purely because he was a specialist looking at a special system, which he was the best person to assist the court, the prosecution, and the defence.
That can come down, thank you. Can we move on to the 9th of February, poll 3005 4085? And if we scroll down, please. Over the page. Scroll up a little bit, please.
Oh, of course.
And again, please. I think that must be an errant reference. I'll move on. Fujitsu 00152979, please. The 22nd of February, you're writing directly to Mr. Jenkins, saying thank you for providing the 2 witness statements in the case. I've given your details to the defence expert, Alistair McLachlan, to contact you with a view to discussing the issues in the case. Just stopping there, the document I was trying to show you was you sending Fujitsu Mr. Jenkins' contact details. And you're confirming here that you've done so. And you continue with a view to discussing the case further and analysing the data as discussed. I'd be grateful to confirm whether he has been in touch with you and you've arranged a mutually convenient time for a meeting. Got to be done as soon as possible in view of the trial date of the 15th of March at Guildford Crown Court. Do you agree that you provided no instructions to Mr. Jenkins as to how he should approach this discussion with Professor McLachlan?
Well, it was a mutual meeting into Mr. The defence expert being, averse with the system to be with a view to discussing the system more than that. Our guy is the expert in the system in the sense that he's a specialist in the system, and he's more or less bringing the defence expert up to date as to trying to get him to understand the system itself. I think it's no more than that. I don't know what instructions I gave. I don't remember, or I don't recall exactly now in detail what this meeting is and what I'm asking him to do, or what he.
Well, you don't tell him what you're asking him to do.
Well,
Do you?
I don't remember what. I think this meeting came about purely because these gentlemen, I think, either met together or they wanted to get together to really set out what they're going to discuss. I mean, I don't know, prepare some sort of agenda, but certainly I do not recall what my involvement in this was.
Well, it was you sending an email to Mr. Jenkins saying, have you had a meeting?
I don't recall exactly where we are with it, because to be honest, the amount of minute detail you're going at this moment in time, I can't assist you, because I don't. The time has, so much time has passed from there to now, and I don't really be able to assist you more than I can.
Do you agree, Mr. Singh, that you failed to tell Mr. Jenkins, A, how he should approach the discussion with Professor McLachlan, B, in what capacity he was instructed to conduct the discussion with Professor McLachlan, C, what issues the discussion should cover, and D, importantly, what record should be made of the discussion?
I don't recall any of that, but
Why didn't you do those things?
I don't recall. I don't know what the circumstances, the way their meeting was set up. Was it a preliminary one just to get him to understand the whole system or not? I mean, it wasn't.
Well, even if it was a preliminary one to get him to explain the whole system, you would say, this is just a preliminary meeting to explain the whole system. Don't go beyond that for the moment, Mr. Jenkins, but please ensure that a record is made of what you say to the defence expert, because that will be disclosable in due course. You must have known that, at least, Mr. Singh.
I don't recall. I mean, I don't recall as to how these circumstances came about, and I think at the end...
Well, the circumstances came about that you sent Mr. Jenkins' contact details to the defence, and then you sent Mr. Jenkins an email saying, have you had a meeting yet? They are the only circumstances.
Well, I think it was in agreement with the defence that they wanted this meeting purely because in order to assist them to defend their client. I can't. I don't know any more than what I'm telling you. I don't recall what happened and what didn't happen.
Can we turn, please, to poll 309 3946? This is an application. It's dated the 24th of February. If we go to the last page, please. Sorry, the penultimate page. I think every other page is blank. Thank you. 24th of February 2010, settled by Keith Hadrill of Furnival Chambers. If you go back to page 1, please. It's an application to stay the indictment against Mrs. Misra. I'll count one of the indictment on the grounds of abuse of process.
Yes.
And if we just scroll through it so you get some context, look at paragraph 2, which tells us the background.
Yes. Yes.
Paragraph 3, which tells us what the case is.
Yes.
If we move on to paragraph 4, please. And then 4, 5, and 6 tell us about the back history. Just stopping there. Mr. Hadrill says, case was called on for trial in May 2009, stood out because of concerns over the reliability of the Horizon computer system. Time was given for this area of evidence to be explored. New solicitors were instructed by the defence. And then at 5, case was relisted for a pre-trial review and directions on the 14th of July 2009, and directions were given which included the Service of Experts report. That's where I got the reference to before lunch, to the autumn of 2009, a direction having been given for the Service of Experts reports. Do you see that?
Yes.
Did you know that a direction had been given for the Service of Experts reports
Well,
as early as 2009?
I don't recall. I mean, I don't. I mean, I don't recall now in that much detail. You're asking me to remember going back.
Okay, paragraph 6. The prosecution, by letter dated the 14th of August 2009, said it would instruct Fujitsu, the supplier and operator of the Horizon computer, to assist as experts. In that letter, the prosecution stated the request for data had been submitted to Fujitsu and acknowledged over the page. And again, this is, so I think we've just missed a bit out at the bottom of the last page but 1. If we just scroll down. And acknowledged. Oh, sorry, the prosecution had stated, if we just scroll back up, that the request for data had been submitted to Fujitsu and acknowledged. And then to paragraph 7, please. This is in total contradiction to the statement received from Gareth Jenkins of Fujitsu, who states that no requests have been made for any data relating to the West Biofield branch. That was the issue we were looking at earlier, as to the defence requesting disclosure of the underlying transaction data as early as 2009, and by February 2010 it still hadn't been obtained. 7 we can skip over. 8 we can skip over. 9, a view of the Post Office machinery and method of working at West Byfleet was undertaken by counsel and solicitors on the 6th of November. Professor McLachlan permitted to view the same on the 17th of November 09. 10, at the hearing on the 20th of November 2009, the prosecution requested the defence help by producing more detailed requests for disclosure. That was done and served on the 30th of November 2009. Despite this, no responses were forthcoming until after the defence listed the matter for mention. Then over the page. At the hearing on the 1st of February, the defence were ordered to notify the prosecution of those matters it regarded as still outstanding. Prosecution had failed until the 1st of February 2010 to instruct an expert. At the court hearing on the 1st of February, the prosecution stated it had identified their expert, Gareth Jenkins from Fujitsu, but not instructed him yet. Court confirmed that the prosecution expert should report by the 8th of February 2010. Short statement was served from Mr. Jenkins. In that report, Mr. Jenkins generally could not assist because he'd not been given sufficient material and documentation. He'd only just been instructed to assist and would need time. Some of the questions raised by Professor McLachlan he didn't understand. Some of the information requested from Fujitsu should come from the post office. And then the defence say this: it's apparent that the prosecution has given no clear instructions to its own expert or provided him with adequate material to assist the court. You would agree on reflection that that's true, wouldn't you?
I don't know. I don't quite the dates. I didn't realise that Mr. Jenkins had been identified that early. I don't recall any of that.
Had you given clear instructions to Mr. Jenkins?
I think I don't know. I don't recall.
Had you provided him with adequate material to assist the court?
I don't recall. I mean, I think, as I've been saying, is that he was there basically to help or assist the prosecution and the defence to understand the system, because I'm not a technical person. I don't know the basics, let alone the actual technology involved here. So, and that's one of the reasons why I was very uncomfortable dealing with it myself. That's why I had the barrister alongside me on one side and the head of criminal law team on the other.
Thank you,
Yes,
Mr. Singh.
it's my case.
I'm sorry, I interrupted you.
Sorry. That's one of the reasons, because it's complicated. It's very, very difficult to be able to do it. So I don't recall it to that much detail. I don't recognise the dates. I don't recall the dates. I thought it was everything more or less started around about February time, but as to when Gareth Jenkins was identified, I don't recall now that it was that early. My conversation with Mr. Jones. Now that you mentioned it, and I think the other difficulty is because of the time period. A lot of the information you're coming up with, you're obviously, this is the sort of area of law you deal with, the inquiry side. This is the first experience of it. I do not recall most of the stuff that is coming up at all. And I thought, certainly not the dates, I don't recall. I think more or less everything was happening really, really quickly in February. I didn't realise that going back in time, 6 months, I don't recall most of what's here. And I think most of it, because it's a specialist area, the law and everything else that involved, I had the barrister more or less looking at it in minute detail. I mean, I was relying on the barrister, more or less. And I think we were working alongside. He was saying, well, I would more or less, as you know, I can say generally that that's how we worked on it. But I do not recall most of what's here, the dates.
All right, thank you. That can come down. So that's an appropriate moment to break.
Right.
We would be continuing with a chronological progression through the instruction of Mr. Jenkins and the compilation of his witness statements, the revelation of material to the defence, the discovery of a bug, and whether that material was revealed or concealed from the court and the defence. So I've got another 37 pages of notes to get through.
Right. I think I think we'll break there, and obviously in scheduling Mr. Singh hereafter, we will need to take account of the time estimate for what remains as well as what is to come.
Yes, so I think it would be appropriate to release Mr. Singh from the obligation that he would otherwise be under, not to speak about the evidence he's to give.
Yes.
When he returns, because we're going to be asking him for a further witness statement on phase 5 and 6 issues, and he'll plainly need to speak to his solicitor about those.
Well, that's the practice which I've adopted in relation to those witnesses who have given evidence but who are returning, is it not?
It is, sir.
Yeah. So, Mr. Singh, we're going to stop this afternoon now. As you will have gathered, it will be necessary for you to return to give further evidence. I can't, I'm sorry, tell you precisely when that will be, but it will be done, the scheduling of your evidence will be done in liaison with you and your solicitors. You are now entitled to speak to your solicitors about your evidence and any further requests for evidence. So I will see you again sometime in the new year.
Thank you, sir. Thank you.
Right, and on Tuesday, I'm right in remembering that we're starting at 11 o'clock. Is that right, Mr. Beer?
Yes, that's right. 11 a.m. Tuesday, please.
Fine. All right then.
Thank you.